Welcome back to Between Two FARS. I'm Warneke Miller, and I'm here with Michael Mark and Robert Tepfer, two of our veteran procurement attorneys with almost 90 years of collective experience in federal procurement law. We have been marching you through what it looks like to be involved in ASBCA litigation, and we're now talking about different aspects of discovery. Today, we'd like to talk to you about depositions. So here's your primer, everything you need to know about doing a deposition for the ASBCA.
I think that the first thing you need to know is you need to, if you're going to depose somebody from the other side, you better subpoena them, and make sure that they're going to show up, because a deposition is an expensive proposition for for everybody involved, from the standpoint of travel, the court reporter, and you want to make certain that that individual is on the hook to be there. And I think Michael in a previous discussion mentioned that you can't necessarily depose everybody you want, because a lawsuit is a business proposition, and at some point that you may not be able to afford it. It's not a legal expense, but it's something the program office will have to pay for. But you need to consider that. And then you need to consider everything you need to get lined up. You normally have deposition books, and that consists of all the documents in Rule 4 that are relevant to that particular witness, and any supplemental Rule 4 or other documents you've obtained, which necessarily have not been put into the supplemental Rule 4 yet, that you have obtained in your document request. So you need to have those documents before you do the deposition, and you need to have the interrogatories before you do the deposition. We were having a discussion with regard to how specific to be in the interrogatories versus the deposition. I tend to like to go in with very broad questions, because I may learn something that I didn't know about before. I can always get more specific, but I'm actually want to educate myself on the case. The broad questions permit them to prattle on about what they know about it, their importance, and you can find out, which almost flows into deposition prep, because doing the deposition and deposing an individual is quite different than defending it. And we were talking about defending it and how you essentially explain, if they ask you the time, do you have the time? The answer is yes or no, and not providing the time, or as some of my witnesses have gone so far as to explain how to build a watch and why time really matters.
Engineers, right?
Yes, and that can get you and your witness in a lot of trouble. And that's where you need to go over the very sensitive areas and explain. Don't try to display tremendous knowledge. Don't try to explain how the process works, all the documents involved, what your role was. If they didn't ask you specifics, don't provide them any information other than what they asked about.
One of the things that I want to make sure that everybody understands is you do interrogatories first. Interrogatories are in writing. So you're going to have sworn statements in writing. Depositions are oral. It's testimony. You're in a room, everybody's talking, and it's being recorded. It's you've got a court reporter there, you're going to get a transcript. When you're doing depositions, you probably want to have at least a basic question set. What are you going to ask each witness? Now, the testimony may cause you to want to ask other questions, but you need to know in advance what it is you want to ask the other witnesses. In addition, as Bob pointed out, you better have very thoroughly prepared your witnesses so they have all the documents, they know what's in those documents, and they know how to answer the question. And the answer to the question is just answer the question. Don't elaborate. And if you don't understand the question, say so. Don't try to figure out what he or she is actually asking. And the other thing is, as you have pointed out as we were getting ready, is it's a good idea for the witness to pause before they answer, so that if the attorneys want to object, they can do so before the answer is given. I think one of the confusing things very often for the witness is we'll object and then tell them to answer the question. Because it's wait a minute, on TV, then the judge says, don't answer the question. No, we're not there. It's very rare in depositions for an attorney to direct the witness not to answer the question. It may happen. I've seen it in civil litigation, not in contract litigation, but it's very rare. So,
but objecting preserves your right to challenge the admission of that answer later, right?
Right, exactly, and that's why you do it. So, so the answer is there. If the objection is overruled, the answer goes in. If the objection is sustained, the answer comes out. Can't be used. So, you need to understand a deposition is not the same thing as an interrogatory because it's not as scripted. You know, with an interrogatory, you can sit down and you can write out the answer. You can edit the answer. You can go and look for the documents. You can ask the lawyers, hey, you know, should I answer it this way? This is what I know. In a deposition, when you're in the room, you can't do that. The lawyers can't answer the question for you. You have to know the answer. And if you can't answer the question, or if you don't understand the question, you need to say so. Don't try to create something just to make the lawyer happy. Another technique that lawyers often do is long pauses between questions. They want the witness to fill that silence up with noise. Don't bite on that. Tell your witnesses, don't do that. When you've answered the question, wait. If he wants to take 2 minutes to ask the next question, let him.
Even if he's staring at you.
Correct. Correct.
One of the things that I've used and I've seen used effectively is they will routinely begin with, where did you grow up? Where did you go to high school? Yep. What was your education consisting of? A variety of questions that will kind of lull you into being relaxed. Routine things that there's no controversy over. And in most depositions, if I'm not really involved in discovery and I know what I want to get into evidence later, and I know what I want from this particular individual, you might have a 4-hour deposition or longer, and there may be only 3 points that I want them to own up to admit. And if I can get that out of them, I have a much different case than I had before. So there may be a lot of fluff and a lot of filler that relaxes the witness, you know, makes them feel okay that this is not as near as bad as they thought it was going to be. And then tangentially, I will get to what I want, and, you know, it will, you know, I won't have scared the witness. I won't have intimidated the witness, because once you do that, they're on guard. Okay, so the lawyers who try to be Perry Mason and really intimidate the witness are really making that witness focus. I don't want them to focus. I want a stream of consciousness where they tell me what their involvement was in tremendous detail, where they volunteer the names of other individuals who were involved, that approved, that concurred. They list other documents that I was unaware of, explain a process or procedure of what was going on that day. I want all of that in true discovery. But I also may want specific things for them to tell me about, admit to, whatever. And you do that by having a very nice flow. You get, in defending the deposition, you explain that process, and you explain, you know, as Warnick was saying, the lawyer is not your friend, that this is what they're going to try to do, that if you're getting relaxed, they're getting ready. And you got to make certain that they're aware of that. You need, if you're, you know, you need to be familiar with each document. You need to go down to each document and ask them questions. Sometimes specific questions, like in an interrogatory, are inappropriate. You may ask them on documents that they authored, why did you use this language? Where were you getting to? Why did you, if this is inconsistent with this other document? Or ask them, and you, as you have an absolute right to, your complaint says this. Do you feel that way? This is where, if you're defending the deposition, you get all your witnesses together at the very beginning. All of your witnesses, not the contracting officer alone, they all have to concur with what is said, because there is no fun in having the CO see it one way and writing it, and then later having the inspector say something that's inconsistent or doesn't support them. Sometimes if you get them all together and you go over each sentence of the answer, They will speak to it and they will sort things out, and you want them to own it. Okay, you don't want to find out in the deposition that they had issues all along and the CO saw it one way and wrote the final decision that way and the subsequent answer that way, and then you get to learn what the inspector really thought. That's no fun.
Do you have any advice for that witness that finds themselves caught with an opposing counsel, deposing them in a way where they're trying to incite the witness? They're trying to upset and get the witness angry so that the witness will make that admission that they're looking for. What kind of advice do you have if a witness finds themselves in that position?
That's your classic Perry Mason. You're badgering a witness that's been asked and answered. You know, you don't do a deposition, in my opinion, without having the phone number for the judge. You know, Your Honor, this is discovery. You know, this is not an interrogation. He's asked this question from every angle. My witness has claimed no knowledge, or alternatively, they stated what these facts are. Can we please move on? And you tell opposing counsel, that's exactly what I'm trying to do. You're not getting the answer you want because this individual can't swear to that answer.
And that's part of the witness prep. The witness needs to understand the lawyer may do that to you, and you need to be able to distance yourself from that and not go for the bait. That's my job, will be to protect you if that happens. But your job is to stick to the answers that you've given, stay calm. Let me be the one that gets mad.
And I will object. Sometimes I object. It sounds terrible. And I got to have it has to have merits, but just to give the witness time to think. Yeah. I will object in a protesting manner with regard to what opposing counsel is saying. And I tell the witness, listen to what I'm saying. If I say the question's ambiguous, you better be thinking about it very carefully. If I'm saying that you need to be more specific, or the question is in the alternative, he's asking more than one question. Be careful of saying yes. If I'm saying it's asked and answered, that means we go no further. Right. You need to listen to what I'm saying along with on the record.
Gentlemen, thank you so much for these insightful tips and procedures for handling a deposition in front of the ASBCA. We really do appreciate your wealth of knowledge and your willingness to share it with us. Until next time, in between two FARS.